Sorry, I'm messing everything up.
Thank you.
Yeah.
All right.
Well, we're very pleased to be here with Martin. As you know, if you're a regular viewer of the show, we let you know that Martin was going to be on. We had him on last year, and he discussed the some of the ins and outs of a 1031 tax exchange for real estate investment purposes. And we got some great information on that. We had a lot of positive comments on that show. And we wanted to invite Martin back. Martin is our personal attorney. He just does an outstanding job, but he does more than just 1031 exchanges. It's one of his specialties, but he is a real estate attorney, and his area of expertise goes very deep. And one of the things that we wanted to ask you about, Martin, was the impact and importance an attorney letter can have if you are buying or selling a home, or if you are just starting a contract, or if you've run into trouble in the negotiation process or trouble with the person that you have contract with. Craig has some personal experience with this. Craig, tell a little bit about it.
So we just kept having the contractor breach the contract over and over. It was their contract, and I reached out to Brenda Kelly and Mike Runyon, and they said, "This is who you want to talk to."
Call Martin
And
Burns.
I'll tell you what, he made our life so much better.
And in Craig's case, the builder was breaching the agreements of the contract. Martin could look at that and quickly identify that, and an attorney letter went off, and it changed the trajectory of that transaction from then on. Once they realized that he was represented and they had an attorney who knew what he was looking at, they couldn't get away with what they were trying to get away with, and it changed everything.
Yeah,
So
it really did.
So that's enough of us flapping our gums. I'm going to let Martin talk a little bit about some of the instances where an attorney letter can be of help and some areas where you might want to consider it.
No, and we write these letters all the time, and I know how much people like to get letters from attorneys. It's not really high on your list.
Yeah.
And I get them too. You know, I get too many lawyers letters. Other lawyers. You get enough lawyers and everyone disagrees. But you know, when I write letters,
Joke somewhere.
well, when I write letters to people, I say, look, I've only got so many tools. I'm a lawyer. I can ask you nicely. I can threaten you, and I can sue you. Right now, we're kind of doing 1 and 2, because you know, and I look at it, and what I tell people in these letters is, I provide them authority. You know, so that they know that I know what I'm talking about. But in there, I keep saying, look, you need to go talk to a lawyer, because you're just about ready to get smacked. You know, and I think if you go to a lawyer and you show the lawyer the letter, the lawyer's going to look at it and say, you know, Burns might be right on this. You probably should stop.
Right.
And I think it's an old Abe Lincoln line that the better half of practicing law is telling your client they're a damn fool and they should stop. Because we get that at times. People come in and they, you know, I look at it and I say, that ain't gonna work. You know, nothing good's gonna happen if you do this. And so there's 2 parts to the lawyer letter. One is you gotta talk to the lawyer. And in doing so, you might find out that you're the one in the wrong and we never get to the letter. And there's value in that. I know people come in and they want to hear what they're paying for, but there's value in a lawyer saying, don't do that.
Yeah.
And I tell people all the time, it's the clients who come in and say, here's what I've done that make me a lot of money, as opposed to the clients who come in and say, here's what I'm thinking about doing. Because
Makes a lot of sense.
yeah, so
If you've already done it, it makes it hard to, yeah.
oh yeah, a lot of times like I say, we're walking behind the parade most of the time as an attorney. But there's a lot of times where we use these letters. You know, with purchase and sale agreements, it comes up a lot of times when someone's threatening to breach. Because the real estate brokers, the Runyons, for example, very good brokers, they write up good purchase and sale agreements. And you don't need a lawyer necessarily in a normal residential transaction. Now, in a commercial transaction, absolutely. You should probably have someone looking over them. In a commercial lease, have an attorney look over them. If there's odd things in your residential purchase and sale agreement, yeah, have a lawyer look at it. And it doesn't hurt. It usually takes about an hour of time to have them look it over anyways. But what commonly happens, and what's been happening a fair amount of late, is sellers realize after they're under contract that at some point they got to leave, and they don't have anywhere to go. And they get cold feet, and they say, well, I'm not going to close. Well, meanwhile, the buyer's got their house already sold.
Yeah.
They need to get somewhere, and then the lawyer letter comes that says, "Dear dummy, this is a contract, and
This is why we love this guy.
well, but if you don't close, here's what's going to happen. I'm going to put a lis pendens on your house because you're not going to sell it to anyone else. I'm going to sue you for specific performance, and then the court's going to order the sale. If you tell the court you're not going to sign it, the court is going to appoint a person to sign on your behalf called the commissioner, a kind of an involuntary power of attorney. And then they're going to award all the damages for the person staying at the Econo Lodge, putting their all their possessions in mini storage, probably an extra move, and all the attorney's fees, because all these purchase and sale agreements have attorney fee provisions. The judgment's going to get put on the record, and so it's coming out of the purchase price. So I write to them and say, nothing good is going to happen at this point forward. You need to close this transaction, and you need to go see a lawyer really quick because bad things are about to happen. And that one works pretty good.
And the fact that you said you're going to blow it up the size of a cardboard.
Yeah.
I love the poster. Was awesome. That was
Well, when we find evidence that's kind of the smoking gun, it's like, I'm going to blow this up to the size of a poster, and we're going to have that in the courtroom. Yes.
Have you ever done that?
Oh yeah. We don't use the
If it works.
we don't use the poster boards nearly as much because they have projectors and things.
Oh.
Sure. Okay.
In the old days, we'd have the kind of the
Come in with all your exhibits.
Oh yeah, we got big old things to haul them in too, but we don't use them anymore. You bring a thumb drive. You bring a thumb drive and a laptop. But other places where we use the lawyer letter a lot is adverse possession, because you got two neighbors who've been living next to each other for years. One of them decides to go get a survey because they looked online at, let's say, the Pierce County GIS that puts little lines around the parcels,
Yeah.
which on it says these aren't accurate.
Yeah.
And the person says, I think you're encroaching on my property. They get a survey, and sometimes they're right. And they're going to go tear down the fence, they're going to tear down the trees, they're going to do all these things. I'm like, hold on. On GIS, you can go back 20 years. Go to Google Earth. You can go back further than that. That fence has been there for well over 10 years. And under adverse possession, it's probably going to stay there.
Yeah.
Or if it's a row of trees or some visible demarcation. And so I write to them and say, not only are you about to make a big mistake, but this is trespass because the property's already shifted to my client. It shifts automatically in adverse possession.
Because of the length of time.
Yeah, the law says it shifts as a matter of law, and the courts just come along later and say, yeah, it shifted 30 years ago. Mm-hmm. But if you go onto someone else's property, even though you think it's yours, and you tear down all their trees, not only you're going to get sued for that, you get hit with triple damages under the timber trespass or the waste statute. And so I line all this out to people in these letters, and I say, go see a lawyer before you do something really stupid. And sometimes they do it. They come back and another lawyer comes in, and then they try to negotiate. And it might be a good thing to get resolved. And a lot of times we do resolve them with boundary line adjustments, boundary line agreements, or sometimes we end up in a quiet title action in the courts. Similar things happen with easements. Someone gets mad at somebody and they decide to put a Jersey barrier across the road. I've had this happen several times. And so then we're down getting injunctions to open up the the road's been there for 30 years. Let's leave it open at least until the court settles it. And the courts like people preserving the status quo. And so a lot of times when people write these letters, or they say they're going to do this, I write the letter and say, don't do it. Nothing you do today is going to change what's happened the last 30 years.
Right.
Let's leave things how they've been, and we'll go down and talk to the kind judge 3 blocks down from my office, and we'll see what happens.
Good to have a kind judge.
Yeah. Well, they're not always. I shouldn't say. I mean, I just got done with motions today. It's Friday. It's motions day here. But we also have earnest money disputes. Those come up all the time in purchase and sale agreements, where someone gets to closing and their financing falls apart. Not theirs. I mean, their loan's closed, but Other people, yeah. There are a couple other.
Yeah, I can honestly say we've never let somebody
Yeah.
get that far into it.
Yeah.
So.
But it happens, and the seller is mad.
Sure.
Because they put, with all the other buyers, and they're already packed up, and the sale falls through. And unfortunately, for most of these sellers, there is a financing contingency, and unless they went through and got that person to affirmatively waive it, it continues out all the way to the date of closing. There's a case on it called Salvo versus Thatcher that I cite all the time that says unless that thing is waived, that contingency is there, and therefore the buyer failed to perform but had legal excuse, which is when you get your earnest money back. It's only if you fail to perform without legal excuse that it's a breach and you lose your earnest money. So we get these all the time where the sellers are mad, and I have to write the letter saying, sorry about not closing on your property, but give us back the earnest money, or it's going to go into the registry of the court. We're going to ask for it, and then we're going to hit you with attorney's fees as well, because that's, again, in the purchase and sale agreement. So we add insult to injury. So yeah, we do that. Partition actions as well. There's all sorts of times where the lawyer letter comes in, and largely, if we have a good, strong case, they work. Not always. I've got some pretty terse responses to my letters.
Sure.
But then we go to step 3, which is the suing part of it. But yeah.
Well, I mean, these are great examples of you might be in a circumstance or have been in a circumstance, or you might be in the future where this applies. And so some great examples of when a lawyer letter, or I kind of like what Martin calls a hey dummy letter, it could help you out, and it's really a good thing to consider. We also have one more question. We had a regular viewer of our show.
Jeff Harrell, who's in Alaska, but from Missouri originally. He has a question for Martin, and I cannot remember what
The question was, as I recall, we were chatting earlier, what can you do as far as estate planning with family members to ensure smooth, orderly transition of real estate upon the death of someone? And there's a couple options. One, of course, is having a will. But if you have a will, you have to go down the street here and probate it, and you get an executor, or the now politically correct gender neutral term is the personal representative, and they then can deed the property. We used to have administrators and administratrix, and executors and executrix, and they just lumped it all together into personal representative.
Right.
But you can do other things. We now have what's called a deed on death in Washington. And it's much like the pay on death accounts in a bank account, where if someone designates someone to pay on death, so if I got a bank account and I say, pay on death to you, I fall over dead, you walk into the bank and present them my death certificate, and they transfer the property or the money over to you. We can do the same thing now with deeds. We put a transfer on death deed in. It does nothing while you're alive. You can revoke it, you can borrow money against it, and the lending stays right in the same position as if that deed never existed, because it doesn't exist until you're dead. I mean, it's there, but it has no force and effect. And if you sell the property off to someone else, it's gone. It's deemed. So we can do that, and that completely avoids probate. All you got to do, take a death certificate down to the auditor's office, you record it. The title companies will pick up the transfer on death deed, the death, now it's yours. We can also do joint tenancy with right of survivorship. I don't like that as much, simply because a transfer on death deed, you don't get my property until I'm dead. A joint tenancy with right of survivorship, you have a present interest in the property, and if you go out and do something stupid and someone sues you, that could lien my property.
Oh.
So we try to keep that out of there. We can also put them in trusts and things like that, but there are a fair amount of things to do. And with husbands and wives, you can still do community property agreements, where it's very similar. You record the community property agreement and the death certificate, and it transfers over at that time. So there's a lot of options on how to do this. If an estate is small and they don't need an administration for anything else, or a probate for anything else, we're using a lot of transfer on death deeds, and it's a good way to go.
I hope that answers your question. That's excellent. Martin, thank you so much for joining us. We always enjoy having Martin on the show. He's so much smarter than us. It's fun to listen to somebody who really knows what they're talking about. If you have a circumstance coming up where you need a hey dummy letter, or you want to ask an excellent real estate attorney specific questions about a transaction or a contract that you're thinking of entering into, or a contract that you think may have been violated, Martin Burns is a great resource. He will take excellent care of you. We've been so happy with his services. Martin, if somebody wants to get in contact with you for a 1031 exchange or a hey dummy letter or a probate issue, what's the best way for them to contact
Well,
you?
the phone number is 253-507-5586. My website is mburnslaw.com or burns1031.com.
Fantastic. Please reach out to him. You won't be sorry. We're very pleased. We've had several of our clients who have contacted Mr. Burns, and he has represented them very well. The feedback we get is always excellent. He's a great
He's
attorney.
the best attorney for real estate in,
Yeah.
in Pierce County.
Yeah.
That's what I'm going to say.
I agree. I agree.
Well, let's not get All right, I'm Craig Lee.
I'm Robb McGee.
And I'm blushing. Martin Burns.
That's Real Talk with Rob and Craig. I think it was awesome.